the way it currently stands, forced labor, slavery takes precedence over rehabilitation and public safety.
Oh, by the way, while the Biden administration gives reparations to everyone but free people, look at the billions he has run over to Ukraine.
We don't have black grocery stores because if you think about it now, just to get in that supply chain, it's almost unheard of.
They don't want the truth to get out. Okay? I don't want to know what my family did or what all these people did and all this stuff like that. Okay?
Come on.
You read that 500-page report.
There's this thing called white superiority and black inferiority. That mindset allows all of the behaviors that we've seen across generations, allows for the construction of these policies and practices and systems and structures that continue to oppress us. This is not a handout. This is a debt that is owed.
You know, Allensworth was like the internet of his time in 1904, 1905.
The total black population in California is about 2.6 million, and then of that, the descendants compose about 2.2 million of that. So California, with a multi-billion-dollar surplus, can absolutely afford to satisfy the international terms for reparations, beginning with compensation.
Any financial obstacle that exists that impedes the success of increasing financial prosperity needs to be dealt with and eliminated.
No matter where we've been, no matter what part of this fight we've been in, we've been harmed, and we had harm done to us specifically.
When I got to Los Angeles, this was some of the worst segregation I'd ever seen. And remember, I'm telling you, I'm from Mississippi.
Because as you can see, I'm giving you broken history right now, you know? But I had to give it to you guys today. I said, no, I got to show them this because it's so precious and nobody really knows about it.
Black people don't have that kind of luxury. Our historically black communities have been redistricted multiple times.
Now listen, if you can't handle the TR roof, don't tune in.
Welcome, family. Thanks for tuning in. Once again, this is the Mass Media Group. I have a marathon.
For another one.
Yep, marathon read. We're reading the California Reparations Task Force report. This chapter is chapter 11, An Unjust Legal System. And I want to thank my fellow filmmaker, producer, business partner, Kim Min, for holding it down on the last. I'm gonna turn this down a little bit. On the last read, excellent read with chapter 10. So yeah, thanks, Kim, for doing that. But before we get
it's important to get this information out there, and it was like I was reading my memoir, reading about stolen labor and hindered opportunity.
Exactly. So before we go, if you hadn't had a chance, well, let's go here first. If you hadn't had a chance to look at the Midterm Madness show and program that we did this past Sunday, check that out. We're actually going to be doing a part 2. I believe the midterm last voting date is November 8th. So we're going to do one more show and to keep everybody up to date, and we'll probably be doing it this Sunday at 11 again, so definitely tune into that. So before, if you didn't watch this show, please watch this show, because we're not going to go back over a lot of the stuff that we did, probably just highlight some stuff, but then we're going to kind of continue on with some of the items that we didn't have a chance to do on Sunday.
Yeah, it's a lot this election cycle, with all of the California Assembly seats are up, and 20 of the Senate seats. So definitely find out who your your legislator is, so you can vet them and cast your votes accordingly.
And also, we live streamed this City of Sacramento Racial Equity Committee meeting. It was held this morning at 10 o'clock. So if you have a chance, please take a look at that. I don't know, Kim, what was your lovely 2 cents on this quote unquote Racial Equity Committee meeting?
I mean, they're putting stuff together as far as racial equity committees. Also, the meeting today, they were getting a report from the newly formed Racial Equity Council that is, not a city body, but it's made up of, organizers, activists, and people who, are activists for social and equity, racial justice. Actually, that outside council, I believe they're calling themselves Racial Equity Council. I actually applied for a seat on that board, interviewed with them, but I did not get the position. But I'm definitely going to be, paying attention and holding them accountable. And that's why we streamed the meeting today.
Yeah, there was another brother who was, I guess he had a public comment, and he said that he applied too, and if I'm correct, and he didn't get the position either. Did you hear that?
The commenters, I mean, they were saying the same thing we've been saying, equity is really not that hard to figure out. You just split things up equally. And since we're looking at these disenfranchised areas that have been historically overlooked, maybe you need to, he just said, just give it to this district, and this district, and the districts that have been taken care of all these decades, they might have to sit a couple years out.
Yeah, as a matter of fact, I'll probably have to go back and look at the recording, but if I'm correct, there was supposed to be a report that was due regarding some of the cannabis initiatives here in Sacramento. And it wasn't even complete. So the brother was like, hey,
it sounds like an initial firm dropped the ball, didn't get it done. And then they had to hire another firm. Sounds familiar, huh? That's a little inside baseball, but so they had to pick up another firm. They're not getting it done. And the commenters were like, if you don't get it done, maybe the people who are in charge of making this happen have to be held accountable by, removing them and getting people in the place that can make it happen.
Yep. So once again, family, check that out. It was some good information, especially check out some of the comments, the public comments. They were actually pretty fire. At first I was like, oh no, it's probably gonna be BIPOC-ish. But some of the commenters came through, and also Kim Mims said her public comment as well in regards to what they're trying to do here in Sacramento to revitalize the business community in Del Paso.
Yep.
So on that note, I guess it's time to get this reading going. I am just not even prepared. I thought I was like ready to go, and then next thing I know, I don't have anything up. I'm glad we talking.
We've been going all day, and an unjust legal system. Actually, Sacramento was trending today on Twitter, and apparently they have like the highest stats of racial profiling for drivers. So definitely we deal with it out here in the capital city.
Wow. Man, I didn't know that.
Yeah. Breaking news.
Oh, speaking of breaking news, while I'm pulling this up, if anybody see the debate between Dell and Newsom? Did you watch the whole debate, Kim, or no?
I scrubbed through it, got to the important parts. I did see that reparations came up, so that's a plus.
I was quite shocked. And so it was just a matter of, for me, because most of the times reparations in these debates aren't brought up. But I got to give a shout out to KQED. You know, we have had some interaction with KQED, and they've been supportive with our efforts as well. So I just want to give a shout out with them.
pushing it out there, pushing information. So
definitely
shout out KQED.
Out.
And that was the only debate that's going to be happening between those two. I understand. So an exclusive scoop.
And actually, Kim, myself, and Chris, we are going to be this Wednesday on Key Matthews. There's a local station, radio station, community-owned radio station, Black-owned, I think. Don't quote me. That we're actually going to be on that show. We're going to be talking about reparations misinformation, because there's a lot of misinformation going on right now in these not only YouTube streets, but you know, Instagram streets, Twitter streets, TikTok streets, social media streets. So we want to, you know, clear up some things that's being misinformed right now. So
we just want to give people the best information possible, so they're not, you know, chasing down rabbit holes, things of that nature. Just stay aware, vigilant, and on top of the most current information.
For sure. All right, cool. Well, we're going to go ahead and get busy. Thank you, as always, Kim, for your presence and your due diligence for these fighting reparations.
All right, I'm going to call back and let you do your thing, but I'm in here.
Cool. What's up, Crystal? How you doing tonight, family? What's up, Darlene? How you doing, sis? Hope all's well. So I'm going to go ahead and start. I'm going to share my screen here. And we're going to go ahead and do what we need to do. Now, hopefully I can get through this whole chapter. If not, we might have to do parts 1 and 2. So sit back and relax. I'm going to try to get out of here probably about 10:30. Might push it to 10:45. So if you have to go, do what y'all need to do. But you can catch it on the replay. But for now, appreciate your support in this timely information. All right, so you know what, this music, fam, I can't. It's a little too much up tempo. I just can't. You know, it's you got to vibe to it. You know what I mean? Vibe, boom. All right. Yeah, I couldn't be doing all that. No, it's 8:45, 8:46 on the West Coast time, and man. All right, here we go. Chapter 11, An Unjust Legal System. Introduction. As discussed in the previous chapters, throughout history, the American government at all levels has treated African Americans as criminals for the purposes of self-control and to maintain an economy based on exploited Black labor. This criminalization of African Americans is an enduring legacy of slavery. These persisting effects of slavery have resulted in the policing of Black neighborhoods, the mass incarceration of African Americans, and other inequities in nearly every corner of the American legal system. This long history of criminalization began with enslavement and has created what some describe as caste-like system in America, where African Americans are in the lowest caste of America's racial hierarchy. As the following chapter will show, this criminalization of African Americans has resulted in a criminal justice system that overall physically harms, imprisons, and murders African Americans more than other racial groups relative to their percentage of the population. While constitutional amendments and federal civil rights laws have tried to ameliorate this mistreatment of African Americans, the inequities that remain are so significant that some scholars have argued that as it relates to African Americans, U.S. society has replaced legal segregation with the criminal justice system. Facts. Interjection. African Americans are more likely than white Americans to be arrested, convicted, and to serve lengthy prison sentences. Black adults are 5.9 times as likely to be incarcerated than white people. The experiences of African Americans with the criminal justice system also result in a general mistrust of the civil justice system, where African Americans also face barriers to accessing justice, such as obtaining a lawyer. In California, the history of the inequities African Americans experience is similar to the rest of the country's history. Although enslavement did not exist on the same scale in California that it did in southern states, California has contributed to the inequities African Americans have experienced and continue to experience. For example, California law once prohibited African Americans from testifying in court cases involving white people. More recently, California's punitive criminal justice policies, such as the state's three-strike law, have resulted in large numbers of African Americans in prisons and jails. Although there is very little scholarship on African Americans' experience of the civil legal system compared to scholarship on their experience in the criminal justice system, there is evidence that African Americans have historically experienced and continue to experience discrimination, such as lack of access to a lawyer, and racial bias among jurors. Section 3 will discuss the historical criminalization of African Americans and implicit bias. Section 3 will discuss discrimination in policing. Section 4 will discuss discrimination trial and sentencing. Section 5 will discuss discrimination in incarceration. Section 6 will discuss the effects of contact with the criminal justice system. Lastly, Section 7 will discuss experience of African Americans in the civil legal system. Man, fam, this is no joke, man. In terms of Roman numeral, and you gotta brush up on them suckers, because never know when it's gonna come in handy. All right, here we go. Criminalization of African Americans. Excuse me. It is well established in the historical scholarship that American society has criminalized African Americans starting with enslavement. Federal, state, and local governments, in order to subjugate African Americans and maintain their enslaved status, criminalize African Americans as a way to control them. The system survived the abolition of slavery and the Civil War, and, as some scholars argue, intensified during legal segregation. Once enslavement ended, white Americans created a new legal and social system that continued to socially control and exploit approximately 4 million African Americans. Southern states passed laws which criminalized African Americans by prohibiting everyday harmless behavior and punishing violations with harsh penalties. State and local governments leased out unjustly accused, prosecuted, and convicted African Americans to private companies to work to pay off their fines. Between approximately the 1870s and 1940s, the system of leasing essentially created a new form of slavery. In the segregated South, laws that segregated African Americans treated African Americans as peripheral in American society by physically separating them from white people. Segregation continued to criminalize African Americans by imposing criminal punishment such as fines and jail time for violations of laws discriminating against African Americans. From approximately the 1950s to the 1990s, law and order, or tough on crime, political campaigns, and the war on drugs resulted in laws that punished African Americans and resulted in their mass incarceration. The Slave Codes and the Fugitive Slave Act. The American legal system's early criminalization of African Americans through legalized social control and punitive laws stretches back to the colonial era and became more punitive over time, as discussed in Chapter 2, Enslavement. Oppression of African Americans began with cases in the first American colony of Virginia. In the 1640 case of John Punch, the courts punished 3 servants running away from their employer. This was one of the first documented court cases involving the rights of African Americans. All right, so we're going to put that in 1640 case. All right, John Punch. The courts punished 3 servants running away from their employer. This was one of the first documented court cases involving the rights of African Americans. 2 of the servants were white and the 3rd was black, but they all committed the same crime. The court ordered whippings for all 3, but ordered that the white servant serve their employer for 3 more years, while it ordered the black servant, John Punch, to serve the enslaver for the rest of his life. Boom. Repeat, reverse, let's go again. The court ordered whippings for all three, but ordered that the white servants serve their employer for 3 more years, while it ordered the black servant, the ancestor, John Punch, Ashe, to serve his enslaver for the rest of his life here on planet Earth. The first laws also treated African Americans more harshly than whites. Virginia passed the Casual Killing Act of 1669, which declared that if an enslaved person died while resisting their enslaver, the enslaver would not be made it legal for enslavers to kill the people they enslaved. According to one scholar, most of the major slave codes were from 1680 to 1682, as they marshaled previously piecemealed legislation into one code. In 1705, Virginia passed an act concerning servants and slaves, which combined older laws regarding forced labor in Virginia. This law prohibited African Americans from engaging in activity that white people were free to do, such as resisting a white person, holding weapons, and leaving their plantation without permission. The laws of Virginia became a model for other southern states throughout the slavery era. Much like Virginia, other colonies adopted their own slave codes and ensured that the law subjected African Americans to criminal penalties more harshly than white people. Eventually, every slaving state had its own slave code. Slave codes in territories like the District of Columbia, states like Alabama and North Carolina, all fundamentally treated African Americans as inferior to white people. Although Americans frequently believed that the North was not segregated, this was not the case in reality. In 1849, the Massachusetts Supreme Court held that segregated schools were permissible under the state's constitution. The Michigan Supreme Court held in 1855 that a steamboat company could refuse to sell an overweight cabin to black abolitionist William Howard Day. Ashe. Courts in southern states even cited to this case, which was in a northern state, when ruling against African Americans in other cases involving segregation in schools, streetcars, and public accommodations. Federal laws and court decisions criminalize African Americans for asserting their human right to be free. The Fugitive Slave Acts of 1793 and 1850 required that all enslaved people seeking freedom by crossing state lines to free states be returned to their enslavers. In 1857, the Supreme Court held in Dred Scott versus Sanford that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the rights and privileges of the U.S. Constitution. There are many documented examples of court laws, court decisions, and associated documents during this time that demonstrated that the American legal system treated African Americans as inferior, with fewer rights, and who were, therefore, subject to more punitive treatment under the law. After the Emancipation Proclamation and the end of the Civil War, Congress made several efforts to safeguard the rights of African Americans. Congress passed the 13th Amendment, which outlawed slavery. Congress also passed the Civil Rights Act of 1866, which defined African Americans as citizens in order to protect the civil rights of newly freed people. To primarily protect their physical safety, Congress passed the Ku Klux Klan Act to eliminate extra legal violence against formerly enslaved people. Congress also created the Freedmen's Bureau in order to provide food, clothing, fuel, and other forms of assistance to destitute formerly enslaved people. But, as discussed in previous chapters, white supremacist Southern politicians rose to power after the contested U.S. presidential election of 1876. U.S. troops withdrew from key cities in the southern states, and the Freedmen's Bureau had already been dismantled in 1872 because of Southern political pressure. As a result, these amendments and statutes were largely ignored or circumvented for a century. The Black Codes. Southern states passed the Black Codes and vagrancy laws to criminalize socially control and maintain formerly enslaved African Americans in a lower social caste and as a source of exploited free labor. Though often confused with segregation laws, the Black Codes existed to criminalize the everyday activities of African Americans in southern states during the years immediately after the end of slavery until the Reconstruction Act of 1867. If arrested and convicted of violations, African Americans again had little to no control over their own lives. This provided an opportunity for white Americans in economic and political power to continue using black labor to support the Southern economy. Moreover, black codes and vagrancy laws were a revival of a legal system that existed during the slavery era and further contributed to the social control of African Americans, enabling their economic exploitation. During slavery, white Americans generally believed that free African Americans were suspicious, as white Americans saw free African Americans as masterless and therefore unhoused or vagrant and most likely fleeing from the law. In some states, police arrested African Americans if they could not prove that they worked for a white employer. They could not change employers without permission. African Americans could not sign labor contracts with a discharge paper from their previous employer. This placed all the power in the employers, much like slavery placed all the power in enslavers, and left African Americans with little control over their ability to find other work. Other black codes supported the forced labor of black children, as discussed in Chapter 8, pathologizing the black family. As part of the black codes, states passed vagrancy laws that declared African Americans who were unemployed and without a permanent residence was vagrants and therefore subject to fines or imprisonment, which criminalized and controlled African Americans. While the black codes ended in the 1860s, ex-Confederate states passed vagrancy laws after the end of Reconstruction. All former states in the Confederacy except except Arkansas and Tennessee passed vagrancy laws by the conditions under which, by 1865. After the police arrested African Americans for minor infractions, they leased them to a private company or a white private citizen who would pay the fine in exchange for the person's forced labor. Under this system, incarcerated people could often never earn enough to pay the plantation enslaver to their satisfaction and allow the plantation enslaver to include exploiting black workers for their many years. Convict leasing and re-enslavement. In a system known as convict leasing, laws in the U.S. Constitution allowed private entities to force formerly enslaved people and descendants of enslaved people into doing the same work on the same land, and even for the same people as African Americans would have done when they were enslaved. Black men and boys were arrested on vagrancy charges or minor violations, fined, and forced to pay off their fine through convict leasing. The convict leasing system was legal because the 13th Amendment allowed forced labor for people who had been convicted of a crime. Still sounds familiar today? Interjection. Therefore, the legal system considered incarcerated people to have few rights because, in the words of the Supreme Court of Virginia, they were, quote, slaves of the state, end quote. In some instances, the private citizens who benefited from this system were former enslavers or even former Confederate soldiers, such as the owner of the Angola State Penitentiary land. Wow. Shout out to them brothers and sisters down there. Interjection. Which was formerly a plantation, as will be discussed below in the incarceration section of this chapter. The conditions under which incarcerated people worked in the convict leasing system were oppressive. Unlike in the slavery era, leases had no incentives to keep incarcerated people healthy or alive. So the convict leasing system was worse than slavery. Working and living conditions for incarcerated people were dangerous, unhealthy, and violent. Archaeologists recently discovered a mass grave of incarcerated people's remains in Sugar Land, Texas, at the Bullhead Camp Cemetery that was once part of the Central State Prison Farm owned by the state of Texas. Damn, fam, Texas family. Looks like some reparations is due down there for sure. Let's continue. In this mass grave on land that was once, Ashe. Let's go back, rewind. Let's give our Ashe to our brothers, and probably even maybe some of our sisters who may have been involved in this mass grave. So let's continue. In this mass grave on land that was once owned by enslavers and their descendants, archaeologists found 95 bodies of men and boys and possibly one woman, all almost of whom were African Americans, who were participants in the state-sanctioned convict leasing system, which existed in Texas between 1871 and 1911. Historical documents showed that incarcerated individuals at this plantation frequently died from heat stroke, malnutrition, extreme physical activity for extended periods of time, and disease. Further, the incarcerated individuals had occupational injuries and wounds from gunshots and corporal punishment. Convict leasing, such as what occurred in Sugar Land, Texas, existed throughout the American South. Further, a variety of individuals and businesses used convict leasing, such as Tennessee Coal, Iron and Railroad Company, which U.S. Steel owned. Scholars indicate that convict leasing gradually ended by around the 1940s, as each state stopped leasing convict labor to private individuals and businesses. Legal segregation and racial terror. During the era of legal segregation, Southern state and local governments implemented a system of legalized social control to separate Black and white Americans. As discussed below, these laws were a legacy of slavery because they criminalized African Americans in a post-slavery era by mandating their separation from white Americans and providing for criminal punishment for any violations. The United States Supreme Court case Plessy versus Ferguson, which upheld the rule of separate but equal, legalized laws that require the separation of African Americans and white people in nearly all public places such as parks, businesses, and public transportation. Laws provided for criminal penalties such as fines and imprisonment through the legal justice system only for African Americans who violated segregation laws. In addition, as Chapter 3, Racial Terror, discusses, government actors and private citizens routinely punish African Americans who violated these laws or even appeared to be breaking racial norms created by white people through extrajudicial means such as lynching, racial massacre, and social fear-mongering. Lynching also contributed to the popular belief among Americans that Black people were assumed to be guilty. White lynch mobs murdered Black suspects who were later found to be innocent. Sometimes these murders occurred for no reason at all, and at least one targeted a pregnant woman and her unborn child. White mobs often framed the lynching as a method of self-defense against African Americans who portrayed as dangerous criminals who posed a threat to white society. Segregation laws were legal until the 1950s and 1960s, when landmark cases such as Brown versus Board of Education and the laws like the Civil Rights Act of 1964 found them unconstitutional or made them illegal. Although Americans often associate segregation laws as a Southern phenomenon, the Northern legal system also discriminated against African Americans and treated them as inferior after the Civil War through court cases and laws. This discrimination is particularly apparent in a line of cases involving the rights of African Americans on railroad cars. In 1867, the Pennsylvania Supreme Court ruled against Mary Miles, who refused to sit in the colored-only section of a streetcar. Courts in southern states such as the Florida Supreme Court and the Tennessee Supreme Court later cited the Miles case. In other cases in which the courts decided against African Americans who sought to sit in the whites-only sections of streetcars. It is also well established that from the 1880s to 1960s, northern states had laws that allowed segregation in schools and public accommodations. Tough on crime era and war on drugs. The civil rights movement ended legal segregation and made explicit discrimination against African Americans in the text of court cases and statutes illegal. However, scholars argue that legalized social control continues today in the legal system despite existing civil rights laws and regulations. These scholars argue that the incarceration of African Americans, particularly Black men, occurs in our legal system in two stages. First, police, prosecutors, and judges have significant discretion as to who they may stop, search, arrest, and prosecute, even in a supposedly racially neutral system. During this first stage, the implicit bias which the previously described history of Americans' criminalization of African Americans created affects decision makers and results in high numbers of African Americans in prison. Second, as discussed above, several court cases prevented legal challenges to racial discrimination. Several laws in the decades during and after the Nixon administration provided for increasingly harsh penalties on criminal defendants that resulted in higher likelihood of African Americans in prison than white Americans. During the post-civil rights era, both Republican and Democrat politicians ran on tough on crime or law and order political platforms that popularized especially punitive criminals, particularly laws prohibiting drug sales, distribution, possession, and use to gain support from voters. John Ehrlichman, who had been Nixon's domestic policy advisor, explained, Quote, the Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and black people. I'm going to repeat that. The Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or black. But by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. I'm just going to take a little sip here. Let you kind of think about that one for a little bit. Much like what Interim describes, and many scholars have noted, Republican politicians essentially sought to appeal to the backlash against the civil rights movement by supporting punitive criminal laws. Democratic politicians such as President Bill Clinton also ran on tough on crime platforms during his campaigns and supported punitive laws once in office. These political campaigns often relied on the negative stereotypes of African Americans as criminals built by the previous 3 centuries of American law and order. George W. Bush produced a series of advertisements for his 1988 presidential campaign against Democratic nominee Michael Dukakis that featured a black man named William Horton. These advertisements exploited the stereotype of black men as predators and rapists of white women. William Horton was convicted of murdering a white woman and stabbing her partner while on furlough through a weekend pass from prison. The furlough was granted through a Massachusetts program when Dukakis was governor of Massachusetts. The advertisement primarily consisted of a voiceover summarizing Horton's crimes and a mugshot where he looked particularly threatening. The advertisement also nicknamed Mr. Horton Willie. The Willie Horton advertisements inaccurately portrayed by bipartisan supported furlough programs. These programs were used in all 50 states and afforded incarcerated individuals the opportunity to leave prison for a certain amount of time to visit family, search for employment, and prepare for life out of prison. Thousands of incarcerated individuals safely took advantage of furlough programs in the nation, and William Horton was the rare tale of a disaster. Once politicians entered office, racist political campaigns morphed into racist policies. In 1971, President Nixon declared a war on drugs. In the speech on it, he described drug abuse as public enemy number 1. This marked the beginning of the federal government's effort to fight illegal drugs by significantly increasing penalties, enforced, and incarceration of people who possessed, distributed, and sold illegal drugs. Rather than treat drug use as a political health issue, the American government chose to treat illegal drug use as criminal justice. Federal and state governments chose to punish drug users rather than offer medical help. The war on drugs, which continues today, is a cause for the high numbers of imprisoned African Americans, as evidence exists to suggest that African Americans use drugs at approximately the same rate or less than white Americans. In the decades that followed Nixon's announcement initiating the war on drugs, Congress passed laws that harshly punished criminal defendants. During the presidency of Ronald Reagan, Congress passed the Anti-Drug Abuse Act of 1986, which allocated $1.7 billion to the war on drugs and provided for mandatory minimum sentencing for various drug offenses. The law included far more severe punishment for the distribution of crack cocaine in a solid pellet form, than the punishment of powdered cocaine in a fine powdered form. Even though there is no scientific difference between these forms of the drug, the law established a 100-to-1 disparity in the punishment created for the distribution of crack and powdered cocaine. All right, I'm going to post that in the chat. What's up, brother Chris? What's going on with you today? Yes, go visit etmediagroup.com and cjecofficial.org. All right, let's get back to it. Distribution of only 5 grams of crack resulted in a minimum 5-year federal prison sentence. Meanwhile, distribution of 500 grams of powder cocaine resulted in the same sentence. In 1988, Congress added even harsher penalties to the law. The change allowed public... Wait, you want to... Oh, let me just make sure I'm reading this right. Distribution of only 5 grams of the crack resulted in... Oh, wow. Okay, let's go back. Distribution... Okay, I had to just really read this one again because I was tripping. Distribution of only 5 grams of crack resulted in a minimum of 5-year federal prison sentence. Meanwhile, distribution of 500 grams of powder cocaine resulted in the same sentence. I gotta put that one in there. That is absolutely asinine. That is absolutely asinine. This is America. In 1988, interjection. In 1988, Congress added even harsher penalties to the law. The change allowed public housing authorities to evict any tenant who allows any form of drug-related criminal activity to occur in ordinary public housing premises and eliminated many federal benefits such as student loans for anyone convicted of a drug offense. An arrest is not required to evict entire families from public housing as long as an agency employee determines that a household member or guest has engaged in drug-related activity. Scholars have argued that these policies perpetuate residential segregation. The laws also expanded the use of death penalty for serious drug-related offenses and imposed new mandatory minimums for drug offenses. This Anti-Drug Abuse Act has had a disproportionate effect on African Americans because African Americans have more commonly used crack cocaine rather than powder cocaine. All right, I'm just for my notes. I want to put this in there because I think I actually want to read this one, this act here, because honestly, I'm not totally familiar with the language that's in here, so I kind of want to read this and kind of break this down with the family. All right. One study found that the probability that a black man would enroll in college dropped 10% after the passage of the Anti-Drug Abuse Act of 1986. Another showed that close to 1/3 of individuals arrested for drug possession in the U.S. are black adults. Some scholars argue that other laws passed during the time intensified drug law enforcement by incentivizing local law enforcement to stop, search, prosecute, and or incarcerate large numbers of people. During the presidency of President Bill Clinton, Congress passed the Violent Crime Control and Law Enforcement Act of 1994, or the 1994 Crime Bill, which made several changes to the law, such as increased federal penalties for many crimes, made a variety of offenses federal crimes, and provided federal funding in ways that encouraged the growth of a more punitive criminal justice system. Some scholars have argued that this bill contributed to the exponential growth of the prison population in the United States, in part by promising $8 billion to states if they adopted truth in sentencing laws, which require that incarcerated people serve at least 85% of their sentences. To name another example, Congress passed the Comprehensive Forfeiture Act of 1984, which, as some scholars argue, incentivizes police to engage in over-policing because it allows them to keep assets of people engaging in criminal activity. Numerous studies around the country have found that the police are more likely to seize money and property from black defendants. Implicit bias. As federal, state, and local governments intentionally and methodically criminalize African Americans, Americans regardless of race began to associate African Americans with crime. This enduring legacy of slavery has resulted in an American society that is biased against African Americans. Psychologists have documented for almost 60 years that the stereotype of African Americans as violent and criminal. This association is not only strong, it also appears to be automatic, unconscious. Other studies show that in cases involving a white victim, the more stereotypically black a defendant is perceived to be, the more likely that person is perceived to be dangerous. A new but growing body of scholarship shows that the police officers are frequently biased against African Americans. New policing technologies, many perpetuate how police treat African Americans because they use algorithms that replicate human biases. Okay, quick interjection. Maybe quick, I don't know. Anyway. So, we have this whole opioid thing. I mean, I don't know nothing about drugs. But anyway, so I guess there's like this whole opioid pandemic thing that has happened within the last few years. And, I just don't see the same energy that happened for this opioid, epidemic, not pandemic, epidemic. Then what happened during this crack era? Where was the war on drugs with the whole, opioid thing? As a matter of fact, I think one of the largest manufacturers had something to do with like producing opioids or something like that. Anyway, they getting sued and people getting paid. Unlike our family, which is predominantly, freedmen who were getting charged and booked for crack, and it decimated, man, our communities. Many of our people, man, got hooked on that crack. If you haven't seen New Jack City, not a favorite. Actually, I'm not a fan of it, but that film shows, I think they called it, what was that, Star Trek? I don't know if you got any Trekkies out there, but Beam Me Up or something like that. Anyway, I think Chris Rock played in it, and who was the other brother? Family, help me out with the dude. Man, I can't remember his name. He was the lead actor. Wesley Snipes. Thanks. Appreciate that the ancestors hooking me up. So yes, Wesley Snipes playing is called New Jack City. Anyway, let's continue. Much like courts in Southern California and northern states, California courts and the legislature also discriminated against African Americans throughout history. In 1874, the California Supreme Court upheld school segregation in San Francisco. In 1919, the California Supreme Court decided a case against a black couple, the Garys, who fought to keep their Los Angeles property against a racially restricted covenant. These cases show that California courts were actively involved in legitimizing discriminations against African Americans. In addition to court cases, California also passed discriminatory laws, as discussed in other chapters. In 1850, the state prohibited marriage between black and white Americans and prohibited African Americans from testifying in civil and criminal court cases that involve white people. The California Supreme Court upheld this law prohibiting testimony from African Americans. Like other states and the federal government, California also passed its own fugitive slave law in 1852. Much like southern states, California also had vagrancy laws. More recently, California passed the Mulford Act on July 28, 1967, which made it a misdemeanor to carry loaded firearms in public. The bill was in response to the Black Panther Party for Self-Defense, ASHE, which was formed in Northern California in 1966 and organized legal armed demonstrations in the state to support and protect African Americans. Excuse me. In February 1967, 20 armed Panthers escorted Malcolm X's widow Betty Shabazz to the Malcolm X Grassroots Memorial in San Francisco. In April 1967, 12 armed Panthers led a protest against a Contra Costa County sheriff who killed a young black man. It was against this backdrop that State Assemblyman Donald Mulford introduced legislation to ban the carrying of firearms in public places. In response to the proposed legislation, a group of Panthers walked inside the Assembly chamber at the California Capitol while carrying firearms to protest. Although Assemblyman Mulford had denied that the legislation was racially motivated, Mulford added a provision to Assembly Bill 1591 that would also include a ban on carrying loaded weapons in state buildings. Ha! That dude. California has also imprisoned black activists Romaine Chip Fitzgerald and Geronimo Pratt. Shout out to Geronimo Pratt, Romaine Chip Fitzgerald, both influential members of the Black Panther Party, were sentenced to life in prison for separate murders in 1969 and 1971, respectively. Even though by 1990 there was substantial evidence indicating that Geronimo Pratt was framed, the California Supreme Court refused to overturn his conviction at the time, and Los Angeles County Deputy District Attorney argued against Pratt's parole, stating he is still a revolutionary man. Okay. Huh? Okay, just quick interjection. He's still a revolutionary man? What does that mean? I mean, don't they say like the American Revolution and all the other stuff? Yeah, hypocrites. Anyway, I digress. Let's continue. While Fitzgerald remained in prison for over 51 years until his death at age 71, Pratt was eventually released in 1996 after documents confirmed that the government's key witness was an undercover police operative who posed as a member of the Black Panther Party. Advocates argue that other black political activists currently in prison in California should be considered political prisoners because they have been denied parole as a result of the political affiliation. I think definitely that should be part of the reparations proposal, if not already, to get all the political prisoners out of California prisons. Let's see. Policing. Police have harassed, brutalized, and killed African Americans since the slavery era. The stereotypes created to support slavery and that have carried through to the modern day have resulted in implicit bias against African Americans in the American public at large and in our police force. Due to implicit bias in policing and the efforts of residential segregation, Black communities are paradoxically both under and over police depending on the type of crime. The police and the American public see African Americans not as victims but as criminals. The legacy of slavery continues to devalue Black lives today, as police are more likely to stop, arrest, and kill African Americans than white Americans. Slave patrols. Slave-era slave patrols were an early form of policing, and one of the first patrols began in the Carolina colony in the early 1700s. Slave patrols were made up of ordinary citizens like farmers, hotel keepers, and bricklayers who banded together to catch, return, and discipline freedom seekers and prevent revolts. Some slave patrol members were community leaders and the enslavers who enslaved large numbers of people in the region. Some slave patrols had written patrol enforcement instructions, member rosters, and correspondence. Others were more informal and simply consisted of all adult men in the community. Slave patrols had many similarities with modern police departments. Much like current police departments, some slave patrols had hierarchical organization structures that mimicked military units with rank such as captain. Slave patrols also used dogs to attack enslaved people by biting them, but also to instill fear, and used bloodhounds to track down people. Freedom seekers learned to run without shoes and put black pepper in their socks to make the slave patrols' bloodhounds sneeze and throw them off their scent. Wow, that was intelligent interjection. Much like slave patrols, police have continued to use dogs against African Americans in the 20th century through the present. Police used dogs against demonstrators during the Civil Rights Movement. The United States Department of Justice noted in its 2015 report that the Ferguson Police Department exclusively set their dogs against black individuals, often in cases where doing so was not justified by the danger presented. In Baton Rouge, Louisiana, police dogs bit at least 146 people from 2017 to 2019, and almost all of whom are black. I'm going to repeat that again for our Louisiana family. In Baton Rouge, Louisiana, police dogs bit at least 146 people from 2017 to 2019, and almost all of them whom were black. Law enforcement targeting of black political leaders. Law enforcement agencies have not only targeted African Americans and physically hurt them, but the federal government has targeted black political leaders to neutralize their effectiveness. As discussed in Chapter 3, Racial Terror, and Chapter 4, Political Disenfranchisement, the Federal Bureau of Investigation and state intelligence agencies like the Mississippi Sovereignty Commission targeted civil rights leaders and activists to deter them. The Mississippi Sovereignty Commission openly discussed murdering civil rights activists and were implicated in false convictions of activists. The Federal Bureau of Investigation has continued surveillance action today against Black Lives Matter organizations. Over-policing. A majority of African Americans live in communities where there are higher rates of violent crimes. As described in Chapter 5, Housing Segregation, due to government-sanctioned residential segregation, African Americans are far more likely than white Americans to live in impoverished neighborhoods with higher rates of violent crime. 62% of African Americans live in highly segregated metropolitan areas that experience a high degree of violent crime, while the majority of white Americans live in highly advantaged neighborhoods where there is little violent crime. As Dr. Bruce Appleyard testified during the December 7, 2021 task force meeting, there may be a connection with formerly red line communities and higher rates of police stopping and searching of African Americans. Studies suggest that police treat African Americans differently than white Americans. Some scholars believe that police arrest large numbers of African Americans for relatively minor crimes, such as loitering, drug possession, and driving infractions. Wow, arresting people for driving infractions? In 2019, African Americans comprised 26% of all arrests, yet they only made up 13.4% of the population. According to a recent large-scale analysis of racial disparities of nearly 100 million state patrol police stops in 33 states, researchers found that police officers stopped African Americans more than white drivers relative to the share of the driving age population. Drivers, after controlling for age, gender, time, and location, are more likely to be ticketed, searched, and arrested when they are black than they are white. There is also evidence that the bar for searching black drivers is lower than for searching white Americans. A 2021 study of traffic stop data in Florida shows that approximately 42% of police officers in that state discriminate during traffic stops, and that minority drivers are less likely to be able to leave with a warning when compared to white drivers. Another study shows that police use more force against Black and Latino suspects in the beginning stages of interactions. Some early data also indicates that police may have arrested a large number of African Americans relative to their proportion of the population for violation social distancing rules during the C-19 pandemic. Some research indicates that American society views African Americans so differently than the rest of the population that marketing professionals have identified and potentially exploited this trend. Marketing has targeted African Americans for consumer products to defy racism and project a middle-class identity. Respondents in one study indicated that being well-groomed is a way to defy racism by showing worthiness. The daily ongoing fear of racial profiling has an enduring lasting effect on African Americans. Former First Lady Michelle Obama discussed her fears about her daughters becoming the victims of racial profiling. The fact that they are good students and polite girls, but maybe they're playing their music a little loud, maybe somebody sees the back of their head and makes an assumption. Many of us still live in fear as we go to the grocery store, walking our dogs, or allowing our children to get a license, Obama said. Policing in black communities, such as through a stop and frisk techniques, communicates to black men that they are objects of disdain by the state and that their citizenship is degraded. A 2000 study of officer-worn body cam footage showed police officers speaking significantly less respectfully to African Americans than to white Americans in everyday traffic stops after controlling for officer race, infraction severity, stop location, and stop outcome. Federal programs and nationwide policing practices have contributed to this over-policing. Operation Pipeline is a federal program in which over 300 state and local law enforcement agencies train officers to use pretextual stops and consent searches on a large scale for the interception of the transportation of drugs. Broken windows, an aggressive crime prevention strategy, emphasizes arresting people for committing both major and minor offenses, was first implemented in New York City in the 1990s. It resulted in arrests of disproportionate numbers of Latino and black youth, under-policing, and the dismissal of black victims. In addition to perceiving African Americans as more dangerous, Americans and police officers are also less likely to view African Americans as victims of crimes, particularly in areas of violence against women and girls and mass shootings. Evidence of such under-policing is apparent in the popular news coverage of many cases in which law enforcement authorities appear to have ignored the disappearance of black women, girls, and children. Although black women experience more sexual violence, black women have historically not received the same level of attention as white women following sexual assaults. As one scholar explains, crimes against black women are poorly investigated and sometimes ignored altogether. When police actually attempt to investigate alleged crimes against black women, they often believe the victims are not credible. Further, the few sexual assault crimes that actually lead to police charges are frequently not pursued by prosecutors, denying black women access to justice. Black women and girls are disproportionately more likely to be victims of sex trafficking in the United States than women and girls of other races. These biases are rooted in history. In 1855, a judge instructed a jury that Missouri's law protecting women who resist sexual assault did not apply to a 19-year-old enslaved woman, Celia Ashe, who killed her enslaver when he was attempting to rape her, after she had already endured 5 years of rape, resulting in the birth of 2 of his children. This trend also extends to crimes against black children. Black children, on average, remain missing longer than non-black children. Black women and girls, in particular, go missing in numbers larger than their proportion of the population. Not only the police, but also the media typically pay them less attention compared to missing white women and girls. All right, I'm just gonna. Wow. Oh yeah, facts. Robotic dogs, that ain't no joke, man. I remember seeing a news story on that, the robotic dogs, man. That was nuts. Police and prosecutors sometimes have also, let's continue. Police and prosecutors sometimes have also improperly handled these cases. In Atlanta, Georgia, during the late 1970s and early 1980s, a serial killer murdered approximately 24 children, many of whom were black boys. Police arrested and prosecutors convicted Wayne Williams of killing 2 adults, but prosecutors never tried or convicted him of killing any children. Even though many believe the murdered the missing children, in fact, prosecutors have never obtained a conviction for the murderers of all the missing children. Quick interjection, there's a current story, and I don't know where it is at, or I guess this white dude This white man was supposedly like kidnapping, and I think even may have murdered, may they rest in peace, some young black women or some black women or something like that. And I think maybe one or two escaped. I don't know, don't quote me. But like this recently happened. Black folks was like, hey, y'all need to check into this. And the law enforcement was like, no, I don't know what you're talking about. So later came out that all this information was true. So, man, this is nuts. Crazy. Anyway, let's get back to it. Similarly, black, transgender, and gender non-conforming people receive inadequate police protection, even though they are more likely to suffer violent crime. Advocates have described an increasing epidemic of violence against the transgender community, and studies show that black transgender women are significantly more likely to experience violence or to be murdered compared to white transgender women. In 2019, for example, black transgender women made up 91% of all transgender people killed by violent crime. Despite experiencing gender levels of violence, black transgender people are also less likely to seek and receive help from the police. This is because black transgender people suffer much higher rates of harassment and assault when interacting with the police. Some very new and limited scholarship shows that mass shootings occur more in black communities than in other communities, and more frequently than is covered in media reports. Part of the reason is due to the fact that the definition of mass shootings is different, depending on the government agency, and the media tends only to cover mass public shooting, rather than mass shootings that grow out of violence between individuals or groups. Employment discrimination. Employment discrimination in police departments against black applicants may exacerbate discrimination and police brutality against African Americans. The Obama administration's Task Force on 21st Century Policing noted in the recommendations that the diversity of the nation's law enforcement agencies was an important aspect of developing community trust in the police. The United States Equal Employment Opportunity Commission has identified problems with hiring, retention, harassment, and promotion of black police officers. Police officers have publicly complained in news outlets throughout the country about issues around discrimination and harassment against black police officers and correctional officers. These conditions have resulted in many departments that have very few black police officers, such as scholars have argued that this lack of diversity in police departments contributes to discrimination and police brutality against African Americans. Extrajudicial police killings. There is a very long history of police officer killings of African Americans throughout the United States. From the slavery era to present day, this history has not been limited to the southern states, but as discussed in Chapter 3, Racial Terror, it's almost part of California's history. A study of thousands of use of force incidences has concluded that African Americans are far more likely than other groups to be the victims of police violence. African Americans are 2.9 times more likely to be killed by police than white people. In fact, the statistics may be worse than this because, according to one study of data from 1980 to 2019, more than half of all killings by police in the United States go unreported in the USA National Vital Statistics System database, from which some analysis is drawn. There are many well-publicized examples of police killing African Americans, such as George Floyd, Minneapolis, Minnesota. Say his name, Ashe. Breonna Taylor, say her name, Ashe. Some have died while in police custody, like Sandra Bland, say her name, Ashe. In Waller County, Texas, others have likely died because of police neglect, such as Matrice Richardson, who appeared in Malibu, California in 2009. Ashe to Matrice Richardson. All right. Fam, I'm going to take a really quick break, about 1 or 2 minutes. Let this beat roll for a minute, and then we're going to continue with California. I'll be right back. All right, fam, we are back. So looks like Darlene, that was in Kansas, a woman escaped. Yeah, thanks for that, family. Saw something about that, said suspect was, yeah, probably. All right. California. Let's see. Actually, let's change it up a little bit on the ones and twos. Let's see what is this. Nah. All right, I guess we'll bounce with this. Okay. California. All right. Police violence against African Americans is similar in California. Statistics from California's Racial and Identity Profiling Advisory Board's 2022 report, drawing on data from 18 law enforcement agencies, including California's 15 largest agencies, shows that police stopped a higher percentage of people perceived to be black for reasonable suspicion that the person was engaged in criminal activity than any other racial group. In 2020, African Americans made up about 7% of the population, but those perceived to be black made up 17% of people police stopped, and 18% of the people police have shot or seriously injured, and 20% of those killed by police. Officers searched, detained on the curb or in a patrol car, handcuffed and removed from vehicles more people who the officers perceived as black than individuals they perceived as white. Search discovery rate analysis showed that individuals who police perceived as black had the highest search rate. People perceived to be black were also more likely to have police use force against them compared to people perceived as white. Police officers also reported ultimately taking no action during a stop, most frequently when stopping a person they perceived to be black, suggesting that there may have been no legitimate bias for the stop. As in the rest of the country, the Operation Pipeline program in California led to racial profiling in the state. In a 1999 report by the California State Legislature, the California Highway Patrol described Operation Pipeline enforcement efforts as a way to find illegal drugs by generating a very high volume of legal traffic enforcement stops to screen for criminal activity, which may include drug trafficking. As one California Highway Patrol sergeant said in an interview, it's sheer numbers. Our guys make a lot of stops. You've got to kiss a lot of frogs before you find a prince. California Highway Patrol canine units were involved in nearly 34,000 such stops in 1997, and only 2% of those stops were carrying drugs. In 1999, the American Civil Liberties Union sued the California Highway Patrol and alleged that Operation Pipeline taught officers, I'm just going to put this in the chat, Operation Pipeline taught officers to stop black and Latino male drivers for little or no reason. The California Highway Patrol admitted in court documents that its officers were twice as likely to stop black drivers than white drivers, and were more likely to ask black drivers for permission to search their cars than white drivers. Relatedly, an analysis data from 2000 to 2008 in California showed that African Americans were significantly more likely than white people to be arrested for a marijuana offense. After the legalization of cannabis in California, news reports indicated that black entrepreneurs who try to start new cannabis-related businesses face challenges and delays, including a slow licensing process. Okay, interjection, as Kim and I spoke earlier in the program with this whole delaying, we got a lot of black folk locked up, for marijuana possession, cannabis possession, but when they get out, can't even get no licenses because a lot of these cities already got their licenses. I believe, what are those places called with the it's off the top of my head. It's the brick and mortar ones, dispensaries. Like all the dispensaries are maxed out right now, so like you can't even have any more dispensaries. Hopefully they're going to be extending that here in Sacramento and throughout other states in California. But yeah, man, it's all a racket. Anyway, let's get back to it. Interjection. For an in-depth discussion of discriminations in licensure, see Chapter 10, Stolen Labor and Hindered Opportunity. African Americans are also increasingly victims of hate crimes both nationwide and in California. According to the Federal Bureau of Investigations, 48.5% of single bias hate crimes incidences were motivated by anti-black bias in 2019. According to the California Attorney General's report on hate crimes in the state in 2020, 34.3% of single bias hate crimes were motivated by anti-black bias. Anti-black bias events were the most prevalent of all types of hate crimes and increased 88% from 2019 to 2020. Okay. So, and shout out to my AAPI family. Shout out to them. But you telling me that black people, according to this, if I'm correct, it says anti-black events were the most prevalent of all types of hate crimes and increased 88% from. So you saying you got an anti-Asian hate crime bill, but you can't have an anti-black hate crime bill and pass it? I'm trying to figure this one out. Let's go. There are numerous high-profile incidences of police killing African Americans in California, such as Ezell Ford, Los Angeles, Kendrick McDade, Pasadena, Ashe, Waukesha Wilson, Ashe, Anthony McLean, Ashe, Oscar Grant, Ashe, Dijon Kazee, Ashe, Richard Reicher, Ashe, Stephon Clark, Ashe, and Alfred Olongo, Ashe. These deaths and many others nationwide have sparked increased activism and public awareness on the issue of police brutality. Activists established the first chapter of Black Lives Matter in Los Angeles, and it is now a global network of activists. Police departments throughout the state have histories of violence against African Americans. Okay, just real quick, I'm just gonna kind of see where we are right here. Let's see. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Okay. All right, fam, we're going to try to get through this. I'm going to try to push through this, trying to punch through it. All right. So once again, it's around 9:52. I'm going to see where we're at around 9:30. All right. So thanks for everyone for tuning in, listening. Appreciate you. In Los Angeles, before the turn of the century, the city's police and a history of violence against other historically marginalized groups such as Native Americans, Latinos, and Asian Americans as more African Americans moved to the city. The time period between the 1920s to the 1960s was characterized by police brutality against African Americans and protests, such as the Watts Rebellion in 1965. Much like many other historical events that are often considered riots, what occurred in Watts was a reaction to injustice or a rebellion. For further discussion of rebellions, please see Chapter 3, Racial Terror. In the 1980s, the Los Angeles Police Department, which is the largest police department in California and one of the largest in the country, referred to black suspects as dog biscuits. Victims of police dogs sued and alleged that the department disproportionately used dogs in minority neighborhoods, which resulted in police dogs inflicting 90% of their reported bites on African Americans or Latinos. In 2013, the special counsel to the Los Angeles County Sheriff's Department, which is the largest sheriff's department in California and the country, found that African Americans and Latinos comprise 89% of the total individuals who were bitten by the department's dogs from 2004 to 2012. During the same time, the special counsel found that the number of African Americans that police dogs bit increased 33%. Often, such incidents of police brutality led community protests that in turn sometimes continued brutality by police. The beating of Rodney King by the LAPD is one such example. Ashe. On March 3, 1991, Rodney King stopped his car after leading LAPD officers on a pursuit. Officers beat Rodney King and were captured on video. The officers were charged, but despite strong video evidence against the officers, were ultimately acquitted. There is also at least some evidence that law enforcement gangs, which are groups of peace officers within an agency that engage in a pattern of on-duty behavior that intentionally violates the law or fundamental principles of professional policing, such as those alleged in the Los Angeles County Sheriff's Department, have exacerbated the brutalization of African Americans by law enforcement in California. In 1990, at least 75 Linwood residents filed a class action lawsuit alleging that the Sheriff's Department allowed the Vikings, a Sheriff's Department deputy gang, to carry out racially motivated violence in the community. In Los Angeles County, which is the state and country's most populous county, as of April 2022, police have killed 964 people since 2000, 24% of who are black, even though African Americans comprise only 8% of the population during that time. Los Angeles police have also historically appeared to ignore the disappearance of black women. Lonnie David Franklin Jr. was believed to have murdered several black women and girls in the Los Angeles area. He was not arrested and convicted until 2016 due to what activists believe was police neglect. In the Bay Area, well, I shade to them sisters who had an untimely death. Let's continue. In the Bay Area, police brutality became such a concern that the Black Panther Party for Self-Defense, which later became the Black Panther Party, formed to provide protection to African Americans from the police during the 1960s. Two young activists, Huey Newton Ashe and Bobby Seale, the legends, saw brutality against civil rights protesters as part of a long history of police violence. Eventually, the Black Panther Party for Self-Defense evolved into an organization that provided several other services to the community, such as medical clinics and free breakfasts for children. In fact, the Black Panthers even engaged in forms of counter mapping, which is a form of activism in which marginalized groups use maps to challenge inequality, to propose the creation of new police districts in Berkeley, California. In the San Francisco Bay Area, according to a study, 27% of the people police killed were black, even though they only comprised 7% of the population at the time. Discrimination by California police against African Americans is not limited to large police departments like the Los Angeles Police Department and the Los Angeles County Sheriff's Department. According to the analysis of traffic stops by the San Diego Police Department from 2014 to 2015, black officers are more, not black officers, scratch that, officers only, are more likely to search and question black drivers than white drivers, even though officers were less likely to find them with contraband. An evaluation of 2016 and 2018 data show that both the San Diego Police Department and Sheriff's Department were more likely to stop, search, and use force against African Americans and people with disabilities than other groups. Further, African Americans were 4.3 times more likely than white people to be arrested by the police department for drug possession, even though research shows that black and white people use and sell drugs at similar rates. The police department also stopped African Americans at a rate 3 times higher than white people. Both agencies use higher levels of force against African Americans compared to other groups. Both agencies use more severe levels of force against African Americans than white people at every level of alleged resistance. After the fatal shooting of Stephon Alonzo Clark by members of the Sacramento Police Department, the Attorney General conducted a review of the Sacramento Police Department's policies, procedures, and training regarding the use of force, and issued 2 reports to help guide the police department's reform efforts. In California's rural and suburban regions, the California Attorney General has investigated and secured a stipulated judgment involving the Kern County Sheriff's Department regarding unlawful practices such as unreasonable use of force, stops, searches, and seizures, and failure to exercise appropriate management and supervision of deputies. The Attorney General has also investigated the Bakersfield Police Department and secured a stipulated judgment for the police department to strengthen its engagement with the community. The Attorney General is also reviewing the practices of the Tolerance Police Department amidst serious allegations of racist text messages, some which contained disparaging comments about African Americans and other discriminatory conduct. As a result of community activism and increased nationwide public awareness of police brutality against African Americans in 2020, in particular, California has recently taken steps to attempt to address the numerous concerns with policing in the state. Assembly Bill 89 raises the minimum qualifying age to be a police officer from 18 to 21 years of age and sets other minimum qualification requirements for police officers in an effort to reduce uses of deadly force. Assembly Bill 750 makes it a crime for a police officer to make a false statement to another police officer if that statement is included in a peace officer's report. Assembly Bill 1506 requires the California Department of Justice to investigate and review for potential criminal liability all officer-involved shootings that result in the death of unarmed civilians in the state. Senate Bill 2 creates a process to decertify police officers for misconduct, preventing such officers from being able to join any other agency in California. California was one of only 4 states without that power. Assembly Bill 118 creates pilot programs to allow community organizations to respond to 911 calls rather than police. Assembly Bill 26 requires officers to intervene if they witness another officer using excessive force and requires officers to report the use of force and prohibits retaliation against reporting officers. Wow. Okay. So this Bill 118 and Bill 26 is very interesting. But these reforms do not alone address the many years of discrimination African Americans have experienced at the hands of criminal justice system, trial and sentencing history. During the slavery era, most states denied African Americans the right to serve on juries, as most states linked the ability to serve on juries to the ability to vote. As discussed in Chapter 3, Racial Terror, African Americans were not allowed to vote in most states during this time. Most states also denied African Americans the right and protections of a jury trial, leaving African Americans vulnerable to unjust convictions. After the Civil War, the Civil Rights Act of 1875 outlawed race-based discrimination in jury selection. As discussed in Chapter 4, Political Disenfranchisement, the 14th and 15th Amendments guarantee black men the right to vote and serve on juries. In some states, racially segregated juries protected the rights of black defendants and prosecuted white perpetrators of racial violence. In the South, after Reconstruction and until the 1960s, numerous allegations of crimes involving black defendants and white victims never made it to trial. Instead, the accused black person was lynched. As discussed in Chapter 3, Racial Terror, prosecutors rarely tried or convicted the white Americans who tortured and murdered African Americans through race massacres and lynchings. The same all-white jurors who did not indict white perpetrators of violence and convicted black defendants imposed harsh sentences for minor crimes, often with little evidence. According to the Select Committee of the state outlined in the report on alleged outrage in the southern states in 1871, in 9 cases out of the 10, the men who commit the crimes constitute or sit on the grand jury, either they themselves or their near relatives or friends, sympathizers, aiders, or abettors. The U.S. Supreme Court did not decide until 1935 that excluding African Americans from juries because of the race was unconstitutional. In Norris versus Alabama, 8 black teenagers were convicted by an all-white jury and sentenced to death for the rape of 2 white women in Scottsboro, Alabama. Despite overwhelming evidence of their innocence, no black person has served on a jury in Scottsboro in living memory. After Norris versus Alabama, many jurisdictions continue to exclude African Americans from jurors by using preemptory strikes or other pretexts. Systemic bias today. Today, systemic problems in the criminal justice system continue to discriminate against African Americans. Courts throughout the country have and continue to be underfunded, which can result in barriers in accessing justice, such as case delays. Although courts in California are now required to take into account an individual's ability to pay when setting bail, in other parts of the country, wealthy defendants can essentially purchase their pretrial freedom through the cash bail system, whereas low-income defendants might suffer additional harsh consequences solely because of their ability to pay. This occurs despite 3 waves of attempts to reform the cash bail system nationwide. As discussed in the civil legal system discussion of this chapter, lack of diversity in the legal profession may also exacerbate the discrimination African Americans face in the criminal justice system. Scholars argue that racial bias against black defendants results in discriminatory choices by prosecutors who make important decisions in the criminal justice system, although empirical evidence exists of such bias only seems to exist in certain types of crimes. Discrimination against African Americans in the criminal justice system not only results from racial biases in police, but also in witnesses and jurors. One study shows that when witnesses knew that the perpetrators were black, witnesses who claimed not be racially biased were more likely to incorrectly identify the perpetrator than witnesses who stated they were racially prejudiced. Lack of diversity on juries continues to be a nationwide problem. A study in North Carolina showing that qualified black jurors were struck from juries at more than twice the rate of qualified white jurors. Scholars have identified the following as factors contributing to underrepresentation on juries: racial discrimination, jury selection, socioeconomic barriers preventing participation by African Americans, judicial discrimination that allows racially demarcated jury representation, and institutional racism and bureaucratic discrimination in perpetuating judicial inequality. One scholar has shown that study participants remembered and misremembered legally relevant facts in racially biased ways. The author of the study argues that implicit racial biases affect the way judges and jurors encode, store, and recall relevant case facts, which leads to the conclusion that implicit memory biases operate in legal decision-making. A lack of jury diversity can also harm African Americans in family courts and the child welfare system, which the Chapter 8, Pathologizing the Black Family, discusses in more detail. The lack of diversity in juries can result in poor trial and sentencing outcomes for African Americans. According to a 2007 report from the United States Sentence Commission, black men who commit the same crimes as white men are given prison sentences that are about 20% longer, even after controlling for prior criminal history. African Americans are more likely than white Americans to be serving sentences of life, life without parole, or sentences of 50 years or more. All right, let's see where we're at. Okay, let's see. 1, 2, 3, 4, 5, 6, 7, 8. Okay, 8.5. All right, 10 o'clock. Let's do it. Capital punishment. As discussed in Chapter 3, racial terror advocates have argued that capital punishment is the modern-day legal equivalent of lynching. The U.S. Supreme Court has acknowledged that the death penalty has a discriminatory effect on African Americans. In Furman versus Georgia, U.S. Supreme Court Justice William Douglas noted that there is evidence of racial discrimination in the imposition of the death penalty, and that an African American would be more likely to get the death penalty when convicted for rape when compared to a white American. Regardless, the Supreme Court still decided that the death penalty is constitutional in some circumstances. Currently, 27 states have the death penalty, while 23 states and the District of Columbia do not. 3 states, such as California, currently have a gubernatorial moratorium on executions. In the states where executions still occur, black men are overrepresented among people federal and state governments execute. A 2015 meta-analysis of 30 studies showing that those responsible for the murders of white people were more likely than those responsible for the murders of black people to face a capital prosecution. California. Historically, California barred African Americans from serving on jurors. Lack of diversity on jurors continues to be a widespread problem throughout California, as a 2020 study showed that racial discrimination is an ever-present feature of jury selection in California. The study found that California prosecutors' use of preemptory challenges to exclude African Americans from juries is still pervasive. In the last 30 years, the California Supreme Court has reviewed 142 cases involving Batson claims, which is the process by which a party can object to a preemptory challenge because of jurors' race, and found a violation only 3 times. In fact, from 2006 to 2018, California courts held that there was a Batson error in just 18 of 683 cases. It has been over 30 years since the California Supreme Court held that there was a Batson violation involving a black juror. Prosecutorial misconduct, which is generally when a prosecutor violates their duty to refrain from improper methods calculated to produce a wrongful conviction, also continues to be an issue in California's criminal courts, as one study of 4,000 state and federal appellate rulings in California from 1997 through 2009 discovered that courts found prosecutorial misconduct in 707 cases, which in average amounts to about 1 case a week during that time. California is one of the several states that have a 3 strikes law. Although amended by Proposition 36 in 2012 to apply to only serious or violent crimes, California's initial 3 strikes law imposed life sentence for almost any crime. Wow. No matter how minor, if the defendant has 2 prior convictions for crimes that were serious under the California Penal Code. The general goal of the 3 strikes law was to deter offenders, particularly violent ones, from committing crimes again. The cases of Leandro Andrade is an example of how California's 3 strikes law was especially punitive and led to excessive sentencing. In 1982, Andrade committed 3 residential burglaries during the same day while unarmed, and when nobody was in the homes he burglarized. Then in 1995, he stole 5 videotapes, which were worth $84.70, and was arrested for shoplifting. Later that same year, he stole 4 videotapes, which were worth $68.84, and was arrested for shoplifting. Under California's 3 strikes law at the time, the 3rd strike could be for any crime and did not necessarily need to be a serious or violent felony. As a result, he received a sentence of, I'm even ashamed to even say this. As a result, he received a sentence of 50 years to life. Come on, man. Interjection. What? Let's continue. These policies have resulted in longer sentences for African Americans in California correctional facilities. Recent reforms in California, which this chapter discusses below, have offered alternatives to incarceration for some individuals, but many African Americans still serve excessive prison sentences for years. Incarceration history. The history of criminalization of African Americans in slavery and the inequities in policing, trials, and sentencing have resulted in an overrepresentation of African Americans in jails and prisons, a phenomenon known as mass incarceration. As this chapter has described, American society began to criminalize African Americans starting from the era of slavery through black codes, vagrancy laws, and segregation laws. Further, law and order were tough on crime. Political campaigns in the 20th century resulted in particularly punitive sentencing and parole systems, which have led to the imprisonment of large numbers of African Americans, although correctional authorities did not always uniformly collect data on the race of prisoners. There's evidence from the U.S. Department of Justice showing that African Americans have comprised the percentage of prisoners exceeding the percentage of the population outside of correctional facilities from at least 1926 to 1986. The percentage of prisoners admitted to state and federal institutions who are black has constantly grown, in which general population trends cannot explain. Although the imprisonment rate of African Americans has generally decreased since 2006, African Americans continue to be overrepresented both nationwide and in California in adult incarceration, solitary confinement, capital punishment, and juvenile incarceration. Adult incarceration. The United States has the highest imprisonment rate, the number of people in prison or jail as a percentage of its total population in the world. Numerous academics, activists, and politicians have called for an end to mass incarceration, and there have been reforms in several states such as Texas, Kansas, Mississippi, South Carolina, Kentucky, and Ohio. These reforms largely focus on reducing excessive prison sentences. However, advocates argue that these efforts are not sufficient to undo decades of prison expansion. One study estimates that at current rates, it will take 72 years to cut the U.S. prison population. Dang. It will take 72 years to cut the prison population in half. Despite reforms, African Americans continue to be overrepresented in prisons nationwide. 20% of prisoners in federal and state correctional facilities were African American, even though they made up just 13.4% of the population in 2019. In 2021, African Americans comprised 38.3% of people in federal prisons across the country. In addition to overrepresentation of African Americans in correctional facilities, federal and state officials continue to use the labor of incarcerated people. And in fact, some present-day prisons were incarcerated, where incarcerated people still perform labor, are on land that was once a plantation where enslaved people worked before the Civil War, and where southern states similarly enslaved African Americans after the Civil War through convict leasing. Angola, Louisiana State Penitentiary shows how, in some ways, the American correctional system continues the legacy of slavery. Angola, which is currently outside of present-day Baton Rouge, was originally a plantation named for the African country from which most of its enslaved people were trafficked. After the Civil War and abolition of slavery, former Confederate Major Samuel Lawrence James received a lease of Louisiana State Penitentiary and all its incarcerated individuals. Under this lease, James subleased the majority of black people who were incarcerated to landowners to replace enslaved people, while others continued to work on levees, railroads, and road construction, while others were given clerical and craftsmanship work. Later, there were also attempts to industrialize prison labor by forcing incarcerated people to make shoes and clothing. In 1898, the state of Louisiana banned convict leasing, and in 1901, the state of Louisiana purchased the prison camp and resumed control of its prisoners. More recently, incarcerated people in Angola continue to engage in production to sell goods such as growing crops like wheat, corn, soybeans, cotton, milo, sugarcane, and even producing art. To this day, approximately 65% of incarcerated people in Angola are African Americans. Correctional facilities such as the Federal Prison Industries of the Federal Bureau of Prisoners argue that these programs teach marketable job skills. Okay. But some academics argue that these work programs are not beneficial. Correctional discipline. African Americans also experience discrimination in the correctional disciplinary system. At least one study has found that while black and white incarcerated people are equally likely to break rules, correctional authorities were more likely to report infractions by black people. There is an overrepresentation of African Americans in solitary confinement. Scholars have defined solitary confinement as when correctional facility officers separate incarcerated people from the general population and hold them in their cells for an average of 22 hours or more per day for 15 continuous days or more. A 2018 study showed that both federal and state correctional facilities place large numbers of black males in solitary confinement. Black males in prisons made up an approximately 42.5% of the prison population, but comprised 46.1% of the people in solitary confinement. Lord. Man, I mean, one, I just couldn't imagine just being in prison, number one, but in solitary confinement? Interjection. Let's continue. Juvenile incarceration. African Americans are also overrepresented in the juvenile justice system. As discussed in Chapter 8, Pathologizing the Black Family, American culture tends to see black children not as children, but as adults. Black students are subject to discipline at a higher rate than other groups in schools nationwide. In 43 states and the District of Columbia, black students are arrested at higher levels relative to their percentage of population. There is also evidence that these racial disparities in school-based disciplinary actions are associated with county-level rates of racial bias. This sort of disciplinary actions and bias contribute to how African Americans are eventually pushed to incarceration through the school-to-prison pipeline, as described in Chapter 6, Separate and Unequal Education, and Chapter 8, Pathologizing the Black Family. Black youth comprise 41% of youth in juvenile facilities, even though they make up 15% of all youth in America. Black youth are more than 4 times as likely to be detained or committed in juvenile facilities as their white peers. Black youth are more likely to be in custody than white youth in every state except Hawaii. As a result of their experiences with the juvenile justice system, many African Americans distrust the system. This report further discusses the enduring impact of the juvenile justice system on black families in Chapter 8, Pathologizing the Black Family. California. The previously described history of the criminal justice system in America, such as California 3 strikes laws and similar policies that have affected large numbers of African Americans, also led to several conditions that have caused California to lead the way in expansion of prisons in the United States until recent reforms. The history, particularly from the 1980s to present, has contributed to what has been described as the biggest prison building project in the history of the world, right here in California. The city of Los Angeles imprisons more people than any other American city. According to one scholar, law enforcement officials often arrested, incarcerated, and or instructed African Americans to leave Los Angeles during the 1920s and 1930s. African Americans are overrepresented in correctional facilities. Approximately 28.3% of California's prisoners were black, when they make up about 6% of the population. Further, black people who are incarcerated in California correctional facilities also experience forms of segregation from the moment they enter a facility. California has a history of extremely poor conditions in its numerous prisons, which disproportionately harms African Americans, as they are more likely to be in prison and to serve longer sentences due to systemic racism. Like the federal government, California still houses and invests in the incarceration of people in large numbers. It houses approximately 100,000 people in its facilities, has forecasted a budget of approximately It houses approximately 100,000 people in its facilities, has forecasted a budget of approximately $227 billion for 2021-22 and operates 35 adult facilities. Let me repeat that. $227.2 billion. In a 2011 U.S. Supreme Court case called Plata versus Brown, the court ordered the state of California to reduce its prison population because the medical and mental health care in California prisons was so bad that it violated the U.S. Constitution's prohibition of cruel and unusual punishment. Since the decision in 2011, California has been required to decrease the number of people in state correctional facilities. Later that year, the state passed Assembly Bill 109, which reduced overcrowding in state facilities by shifting incarceration responsibilities from the state to local authorities for certain people convicted of low-level offenses. California also passed several other laws to reduce its prison population, including Proposition 36 limits California's 3 strikes law to serious or violent felonies for third strike offenders and establishing a process for third strike offenders to ask a court to reduce their term under certain circumstances. Assembly Bill 2942 allows courts to resentence a defendant on the recommendation of district attorneys. Assembly Bill 567 requires criminal courts to only impose a maximum term if a jury considers aggravating facts regarding the offense and permits a criminal defendant and other parties to dispute facts in the record or present additional facts for the purpose of sentencing. Senate Bill 73 ended the prohibition against probation and suspended sentencing for certain types One minute. Certain types of drug offenses. Assembly Bill 484 changes the requirement that a person who is granted probation after being convicted of furnishing or transporting certain controlled substances serve 180 days in the county jail as a condition of probation. Senate Bill 136 ended a sentence enhancement that added an extra year for anyone convicted of recommitting a felony for each prior prison or felony jail time they already served. Assembly Bill 32 prohibits California as a state from entering into or renewing contract with a private for-profit prison to incarcerate people. Other laws attempt to end private financial incentives to incarcerate large numbers of people in correctional facilities. Assembly Bill 2442 or the Racial Justice Act prohibits the use of race, ethnicity, or national origin to seek or obtain convictions or impose sentences. Okay. The Racial Justice Act is also an attempt to address previous court decisions and systemic issues in the system's criminal justice system, which have made it nearly impossible for criminal defendants to challenge racial bias. Many of these laws are new, so it is difficult to evaluate their impact on African Americans. While individuals serve their prison sentences, the state of California uses their labor in many ways. The California Prison Industry Authority produces myriad products such as clothing, furniture, cleaning products, and food. They also perform a wide range of duties in such areas as laundry, kitchen, and general maintenance. The California Department of Forestry and Fire Protection employed around 1,600 incarcerated individuals to fight forest fires in May 2021. As previously discussed, some scholars have challenged the value of these programs because they do not necessarily provide incarcerated people with marketable job skills. Incarcerated individuals are often tasked with low-skill work, and obtaining a job as a firefighter can be particularly difficult, even for people without criminal records. Although California has attempted to reform its juvenile justice system in recent years, it has a well-documented and troubled history of juvenile incarceration. The number of incarcerated youth reached unprecedented heights in the 1990s. California housed over 10,000 youth in 11 facilities throughout the state in 1996. Since that time, the state has attempted to make several systemic reforms to not only reduce the population of incarcerated youth, but also to improve the treatment of youth who are in such facilities. There have also been recent attempts to decentralize the juvenile justice system and provide localized services for juveniles who are accused of crimes. To that end, most recently, Senate Bill 823 provided for the closure of the California Department of Corrections and Rehabilitation's Division of Juvenile Justice, forming the California Youth Authority, and established the Office of Youth and Community Restoration in the California Health and Human Services Agency. But many racial inequities for young African Americans remain. Currently in California, Black youth are 31.3 times more likely to be committed to imprisonment in the state's juvenile justice system than white youths. As of June 2020, of the total 782 youth in California juvenile detention facilities, 227 were Black. In that time, Black youth made up 36% of those committed to a juvenile detention facility, even though they comprised only 14% of the population in California. The treatment of Black youth as criminals in California begins at an early age when they are in school. School administrators, teachers, and school police often treat young Black students as criminals. As Jacob Jackson testified on the October 12, 2021 task force hearing, he was targeted by his teacher and school police when he was a student at Crenshaw High School in Los Angeles. More information on juvenile justice system in California is available in Chapter 8, Pathologizing the Black Family. Effects. The lingering negative impact of contact with the criminal justice system are wide-ranging and far-reaching. African Americans who have had contact with the criminal justice system experience significant discrimination when looking for a home or a job, when they are trying to vote or serving on juries. Just observing the effects of criminal justice system can negatively affect the mental health of African Americans and lead to mistrust of the legal system. Although California has passed laws to limit the lingering harms of the criminal justice system, these changes will not fully address the many years of effects of contact with the criminal justice system that many African Americans have experienced. Devon Simmons, who served 15 years in prison for crimes he committed as a teenager in Harlem, explained, "You've got to find a way to reinvent yourself and promote yourself to the world. But there's a stigma for a... Let's see, did I skip? There's a stigma for a long time. There's a stigma for a long time. For example, any application for schools..." Wait, hold on a second. Where are we at? Okay. But there's a stigma for a long time. For example, any application for school, housing, a job, you needed to check the box saying you're formerly incarcerated. The disenfranchisement pushes a lot of people into the informal market selling drugs, for example. Lingering discrimination. African Americans who have been incarcerated experience problems finding a permanent place to live. As discussed in Chapter 5, Housing Segregation, African Americans have experienced homelessness dating back to slavery, regardless of whether they have participated in the criminal justice system. African Americans who have been incarcerated experience significant levels of housing instability soon after they leave prison. The Prison Policy Initiative estimates that returning citizens are almost 10 times more likely to be unhoused than the general public. And the problem among Black returning citizens is worse than other racial groups. Another study offers an example of the collateral damage of incarceration. Having a recently incarcerated father greatly increases the risk of child homelessness, a phenomenon that is more likely experienced by Black children than white children. Finding jobs is also difficult for Black returning citizens. Lack of employment opportunities for returning citizens can have a broader negative impact on their families. Scholars argue that the high number of incarcerated members of Black families contribute to the Black-white wealth gap. Although the Civil Rights Act of 1964 prohibits consideration of a job applicant's criminal history if it negatively impacts Black job applicants, these cases are difficult for plaintiffs to prove. The Equal Employment Opportunity Commission, the federal agency which enforces civil rights laws in employment, recognizes that employers' consideration of conviction of arrest are factors that are particularly problematic for Black men because they are more likely to have criminal histories. To address this issue, there is a nationwide movement to prohibit employers from considering a job applicant's criminal history before employees consider their qualifications for a job. This movement is also referred to as the Ban the Box movement. Currently, 36 states and over 150 cities and counties have banned the box, or prohibited employers from asking about convictions or arrest history, and delay background checks until later in the hiring process. But much like other criminal justice reforms discussed in this chapter, these new laws do little to address the many decades of discrimination Black returning citizens experience when looking for work throughout American history. Laws that deprive people with convictions of the right to serve on a jury also disproportionately harm African Americans. Some states exclude people from serving on juries when they commit misdemeanors, although reliable nationwide statistics on the number of Black people who cannot serve on juries is unavailable because no national database exists to track such data. Because African Americans are incarcerated more than other groups, they are more likely to be excluded from jury participation as well. As discussed above, lack of jury diversity is the legacy of slavery and a serious and nationwide problem. Some states also deprive people who have criminal convictions of the right to vote. A 2003 study found that regions with large non-white prison populations are more likely to pass laws restricting the right of people with convictions to vote. Depriving people who have convictions diminishes the political power of African Americans. The Sentencing Project estimates that approximately 1.3 million African Americans of voting age cannot vote because of past convictions, which is a rate 3.7 times greater than that of non-African Americans. In fact, over 6.2% of the Black population cannot vote because of what the hell? And over 6.2% of the Black population cannot vote because of past convictions, compared to 1.7% of non-Black population. Oh, that's nuts. Let's continue. Contact with the criminal justice system through incarceration affects the mental health of African Americans. Studies show that incarceration was associated with perceived discrimination, depressive symptoms, and psychological distress. And the impact is long lasting. Incarceration negatively affects the overall physical health of Black people after they leave prisons and jails, as discussed in Chapter 12. Harm and neglect, mental, physical, and public health, as discussed in Chapter 8, pathologizing the Black family. There is also evidence that mass incarceration negatively impacts family members of African Americans who have been incarcerated, both during and after their incarceration. Let's go. Even for African Americans who have not had direct contact with the criminal justice system, just observing the effects of the criminal justice system takes a toll on African Americans' mental health. A 2018 study found that a police murder of an unarmed African American triggered days of poor mental health for African Americans living in the state where that murder occurred. This total number of painful days over a year was comparable to the rate diabetics experienced. Okay, these negative experiences with the criminal justice system have caused many African Americans and Black men in particular to distrust police. As a result, African Americans are less likely to call the police than Latinos and white people. This distrust likely leads to an underutilization of police and government services in general, such as the civil legal system, as will be discussed below. As the Kerner Commission noted in 1968, quote, to some Negroes, police have come to symbolize white power, white racism, and white repression. And the fact is that many police do reflect and express these white attitudes. The atmosphere of hostility and cynicism is reinforced by a widespread belief among Negroes in the existence of police brutality and in a double standard of justice and protection, one for Negroes and one for whites. All right, family. I think, oh man, I don't know when we're gonna have time to do this, but I think we might actually, we're gonna still continue, family. So thanks for hanging in there with us. But I think we might one day read the Kerner Commission report. I don't know when, can't make any promises on that one. But yeah, I think that's one to read. To some Negroes, police have come to symbolize white power, white race. Okay, that we already read that. California. In California, as discussed earlier, courts also contributed to the growing body of law that discriminated against African Americans. California's Fair Practice Act specifically and explicitly banned testimony by Negroes or persons having one half or more of Negro blood in any civil court case to which a white person was a party. Free Black activists who were enslaved people's greatest allies could not be witnesses in any court proceedings. All right, family. That's the California's Fair Practice Act. All right, I'm gonna put this in there. All right, family, because we building our case, right? You know, people say, "Oh, you blessed it." You know, California, free state. Currently, there is some evidence that African Americans experience discrimination in the civil legal system. The civil legal system is a system through which African Americans can obtain remedies such as money for the discrimination they experience in nearly every area of their life, as identified in the chapters on labor, education, housing, racial terror, and wealth. But African Americans with low incomes face several systemic problems in the underfunded court systems, both nationwide and in California, when attempting to access justice, such as obtaining a lawyer. There appears to be very little scholarship on African Americans' distrust of the legal system as a whole and how that affects their underutilization of the civil law system. But some evidence does indicate that their contact with the criminal justice system negatively affects trust in the civil legal system. The California Judicial Council Advisory Committee on Racial and Ethnic Bias provided some helpful insight when it studied the treatment of minorities in state courts and public perceptions of fairness in 1997. The committee noted in 1997 that members of the council had developed the impression from opinion surveys of over 2,000 Californians and public hearings that many minority group members do not believe that they will receive equal justice in the California courts. Several speakers pointed to the large percentage of minority group members, particularly African American males, who inhabit states' jails and prisons. In California, returning citizens still experience discrimination in the areas of housing and employment, jury participation, and voting. Much like under federal law, housing providers may lawfully consider the criminal history of returning citizens under California law. As a result, Black returning citizens still face many barriers when obtaining housing. California has made some recent progress towards implementing reforms to mitigate the effects of contact with the criminal justice system in the state by passing the following laws. Proposition 47, the Safe Neighborhood and School Act. This 2015 law essentially allowed people convicted of non-serious felonies to mitigate the effect of their convictions. Proposition 57, the Public Safety and Rehabilitation Act 2016. This 2016 law sought to give people who committed nonviolent crimes an opportunity for early parole. Assembly Bill 1076, the Clean Slate Act. This 2018 law allows automatic criminal record relief in certain circumstances and makes several other changes to make it more difficult for employers to discriminate against certain people who have had contact with the criminal justice system. Assembly Bill 1008, the Fair Chance Act. This 2018 law made it illegal for most employers in California to ask about the criminal record of job applicants before making a job offer. Senate Bill 393, Consumer Arrest Record Equity Act, the CARE Act. This 2019 law allows for any person who is arrested but not convicted of a crime to ask a court to seal their record. Senate Bill 310, the right to a jury of your peers. This 2017 law allows people who were convicted of a felony to serve on juries if they have finished their prison time and are not on parole, probation, or other post-prison supervision. And Proposition 17, this 2020 voter initiative restored voting rights to people on parole. While these new laws certainly help mitigate the negative effect an arrest and conviction can have for someone who has had contact with the criminal justice system, they do very little to remedy the many decades of discrimination African Americans have suffered before California passed these laws. Discrimination in the civil justice system. The civil legal system is an essentially important part of the legal system in the United States because it is a system through which Americans can solve common and ordinary problems. Americans must use the civil legal system to solve everyday problems in nearly every area of life, such as family law, housing, health, finances, employment, government services, wills and estates, and education. Nationwide, approximately 47% of Americans experience at least one civil legal problem in their household each year. Unlike in the criminal justice system, there is no constitutional right to counsel in all types of cases in the civil legal system, but a lawyer is crucial to prevailing in any civil case. Historically, African Americans have experienced discrimination in the civil legal system nationwide and in California. American government and its citizens have used the civil legal system to subjugate African Americans during and after slavery. For an in-depth discussion of the impact of the civil legal system on labor and employment rights, see Chapter 10, Stolen Labor and Hindered Opportunity. African Americans today continue to face numerous barriers in access to civil justice, including lack of resources and access to courts, and lack of diversity in the legal profession. Systemic barriers. The U.S. Supreme Court notoriously held in Dred Scott versus Sandford that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the rights and privileges of the United States Constitution. We're going to repeat that one more time, family. We're going to repeat this. Okay, so when people come talking to us about reparations, this was our own Supreme Court who felt about their own American citizens. The U.S. Supreme Court notoriously held in Dred Scott versus Sandford that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the rights and privileges of the U.S. Constitution. Okay. We're going to highlight that one. All right. Thanks, family, for hanging in there. We're almost done. We're almost there, family. We're almost there. After slavery ended, many federal civil decisions harmed African Americans, such as cases that legalized segregation, that prevented the federal government from outlawing racial discrimination by private citizens, and that protected the economic liberties of white Americans over civil rights of African Americans. Further, in many states throughout the country, African Americans could not testify in a case in which a white person was a party. These government actions that occurred after slavery ensured African Americans remained in the lowest caste of the American racial hierarchy. Evidence exists that African Americans' negative past experience with the criminal justice system contribute to resistance to seeking help from the civil legal system. One study has shown that black claimants are underrepresented in federal court cases and white claimants are overrepresented. Members of historically marginalized communities, including African Americans, have long faced difficulties accessing justice due to systemic problems like underfunding. Underfunded courts have reduced hours and staff, resulting in case delays and a decreased ability to provide services such as resources for litigants without lawyers. These problems particularly affect people with low incomes who are disproportionately black. According to Legal Services Corporation, which Congress created to provide attorneys to low-income Americans, approximately 21% of people who have family incomes at or below 125% of the federal poverty line identified as black in 2016. In that same year, approximately 71% of low-income households experienced at least one civil legal problem, which included issues with domestic violence, veterans benefits, disability access, housing conditions, and health care. Americans with low incomes received inadequate or no legal help for 86% of their civil legal problems in 2016. Lack of diversity in the legal profession. Historically, law schools and bar associations have discriminated against African Americans by preventing their entry law schools and the profession, as discussed in Chapter 6, Separate and Unequal Education. Predominantly white graduate schools, like law schools, routinely excluded African Americans until the 1960s. The American Bar Association, the main profession associated with attorneys in the United States, prohibited African Americans from joining until 1943. Black lawyers founded the National Bar Association instead. Oh gosh. The American Bar Association, the main profession association of attorneys, repeat, in the United States, prohibited African Americans from joining until 1943. Black lawyers founded the National Bar Association instead. Chapter 10, Stolen Labor and Hindered Opportunity, provides an in-depth discussion of racial discrimination against African Americans by professional guilds and licensure processes. The American Bar Association initially rescinded the membership of William H. Lewis in 1912, the first black assistant U.S. Attorney General, and two other black men, because leaders determined that they had elected him in ignorance of material facts and that the settled practice of the association has been to elect only white men as members. Today, scholars argue that the law school admissions test and law school accreditation continues this discrimination. Scholars also argue that the bar exam, the licensure exam for lawyers, is culturally biased against and designed to exclude historically marginalized groups like African Americans. Nationwide, in 2020, African Americans comprised 8% of students in law school, but only about 5% of lawyers, even though they were 13.4% of the country's population. Only 66% of African Americans passed the 2020 bar examination on their first attempt nationwide, which is the lowest passage rate when compared to other racial groups. As a result, African Americans are underrepresented in the national legal profession and federal judiciary. These statistics have remained almost unchanged since 2011. Nationwide in 2020, African Americans comprise 9.8% of federal judges, even though African Americans make up 13.4% of the population. In general, lawyers in the legal system are particularly important as they play a vital role in the preservation of society. And an officer of the legal system and a public citizen have special responsibilities for the quality of justice. Scholars argue that a law degree is a springboard to lucrative and powerful careers, which are closed off to many African Americans. Advocates argue that Black attorneys provide Black litigants and defendants with much needed and effective, culturally appropriate legal services. California. These same issues exist in California. Much like California criminal courts, the state's civil courts have been historically underfunded, which leads to many conditions that result in inadequate resources for the public, such as limited services for self-represented litigants, decrepit facilities, or decrepit. Whew. Okay, we're gonna make it through. Decrepit facilities and limited court staff. Let's see, limited court staff. As a result of underfunded courts, civil cases move slowly and cases are often not resolved for years. The C-19 pandemic, which caused statewide court closures and resulted in continuances of hearings and trials, has also further lengthened the time it takes for civil cases to resolve. Approximately 55% of Californians experience at least one civil legal problem in their household each year. But according to the State Bar of California, 85% of Californians receive no or inadequate legal help for their civil legal problems. People with low incomes, many of whom are Black, struggle with problems related to housing, health, finances, employment, family law issues, disability benefits, and many other civil law issues. California has passed laws that provide for counsel in certain civil cases, like those involving family law issues. But overall, in the vast majority of civil cases, there was no right to counsel both nationwide and in California. Some studies show that African Americans in particular face unique impediments in obtaining access to a lawyer. One study showed that those with Black-sounding names receive 1/2 the callbacks of those with white-sounding names in response to calls for legal representation. Although African Americans are not underrepresented in the California judiciary, they are underrepresented in the statewide legal profession. In 2020, 8% of judges were Black. In California during 2019, African Americans comprised 4% of lawyers, even though they comprise 6% of the population in the state. These numbers have remained stagnant in the last 30 years. While this lack of diversity presents a problem for creating trust in both the criminal and civil legal system, it is especially problematic for African Americans because it is a system through which they can address the discrimination they continue to experience, as this report discusses in the across all of its chapters. Conclusion: rooted in the tools to maintain slavery, social control of African Americans continue through American history as the Black codes and segregation laws. Federal and state governments continue the legacy of slavery by criminalizing African Americans today. California court cases and statutes contributed to a national body of law that explicitly discriminated against African Americans. As a result of legalized discrimination against African Americans, the American general public developed and perpetrated biases and stereotypes against African Americans. American politicians capitalize on those racist stereotypes to win office and implement more laws and policies that have imprisoned more African Americans than white Americans compared to their shares in the population. This ensured that African Americans remain in the lowest caste of the American racial hierarchy. Much like in the criminal justice system, the effects of slavery in the civil legal system have caused African Americans to experience significant inequities. African Americans, particularly those with low incomes, experience numerous barriers in the underfunded court systems, both nationwide and in California, that prevent them from accessing justice in civil courts. Woo-wee! All right, we're going to be reading chapter 12, Mental and Physical Harm and Neglect. Be here tomorrow, 8:30. Thanks everybody for coming through. as always, appreciate you. Just keep your mind right, keep your mind open. Once again, if you haven't checked out the Midterm Madness, go check that out. Let's see what else is going on. Yes, check out the Racial Equity Committee meeting. That was actually a pretty good meeting. You can make your assessment on what's going on in Sacramento, and I don't know, family. We'll have to see. I mean, America's been talking about racial equality for all this time, and it's no justice but just us. So just 2 cents. So today we went over chapter 11, an unjust legal system, from the Cali Reparations Task Force Report Marathon Read, right here Monday through Friday, 8:30 p.m. for the only media platform that has been on the ground with this California reparations. There is no other media platform outside of Emitting the Mass Media Group that has been boots on the ground with this California reparations movement and the task force. All right, family. So once again, please like, share, hit that subscribe button. And on that note, love, peace, and reparations. Until then, see you.
The way it currently stands, forced labor, slavery takes precedence over rehabilitation and public safety.
Oh, by the way, while the Biden administration gives reparations to everyone but free people, look at the billions he has run over to Ukraine.
We don't have black grocery stores because if you think about it now, just to get in that supply chain, it's almost unheard of.
They don't want the truth to get out. Okay? I don't want to know what my family did or what all these people did and all this stuff like that. Okay? You read that 500-page report.
There's this thing called white superiority and black inferiority. That mindset allows all of the behaviors that we've seen across generations, allows for the construction of these policies and practices and systems and structures that continue to oppress us. This is not a handout. This is a debt that is owed.
Allensworth was like the internet of his time in 1904, 1905.
The total black population in California is about 2.6 million, and then of that, the descendants compose about 2.2 million of that. So California, with a multi-billion-dollar surplus, can absolutely afford to satisfy the international terms for reparations, beginning with compensation.
Any financial obstacle that exists that impedes the success of increasing financial prosperity needs to be dealt with and eliminated.
No matter where we've been, no matter what part of this fight we've been in, we've been harmed, and we've had harm done to us specifically.
When I got to Los Angeles, this was some of the worst segregation I'd ever seen. And remember, I'm telling you, I'm from Mississippi.
Because as you can see, I'm giving you broken history right now, but I had to give it to you guys today. I said, no, I got to show them this because it's so precious and nobody really knows about it.
Black people don't have that kind of luxury. Our historically black communities have been redistricted multiple times.
Now listen, if you can't handle the TR roof, don't tune in.